Okay, Jose Antonio, so I think we are ready to go.
Perfect. So you can, excellent. Good afternoon, and in Washington, D.C., Eastern Standard Time, and good evening in Ukraine and in Europe. Today, we are beginning part of our World Arbitration Update Europe Day, and we have, it is a pleasure for me to be here with our special speaker, Daniel Bilek, and the session is an update of the Ukraine situation from the legal trenches. Daniel Bilek is a Canada qualified lawyer with over 30 years of experience and professional experience in Central and Eastern Europe. He's a partner with international law firm King Stellar and director of the firm's Ukraine practice. Before joining King Stellar, he was the chief investment advisor to the Prime Minister of Ukraine, and he headed Ukraine Invest, the Ukrainian government's foreign investment promotion agency. Dan currently serves in the Territorial Defense Forces, a branch of the Armed Forces of Ukraine, and has recently been recognized by the Minister of Defense for the support to the Armed Forces of Ukraine. We have, at World Arbitration Update, we have taken the invasion of Ukraine by Russia very seriously. And last year, we did our first impromptu panel in the summer of 2022. And this year, we continued with related topics in World Arbitration Update and also Washington Arbitration Week. Now in 2023, we made a special day with our special speaker now. So I believe that that our public, our people who subscribe to World Arbitration Update will find this useful. First, to know what the status is, and after Dan's special speech, we will move into the various options that there may be for arbitration, enforcement, and asset tracing of assets of Ukrainian nationals. So Dan, welcome, and we're very attentive as to your status of the situation.
Well, thank you very much, Jose Antonio. It's a real pleasure and, in fact, an honor to be here among peers. It's oftentimes difficult to know where to start when you're saying what's going on the ground, because notwithstanding what you hear in the press about stalemates and things like that, it's never really a dull moment. You know, Ukraine today is really at the epicenter of global change, and that includes the legal profession, it includes the geopolitics, it includes economics. I think in many respects, and people haven't really woken up to this, the old rule books are being tossed away. And, you know, and I think that's probably one of the lessons that we take from this war, is that here we had not so long ago this notion, especially in the EU, that you would have a Europe whole, at peace, and free from Lisbon to Vladivostok. That somehow the rules-based international order is going to draw, especially Russia, which controls the landmass of Central Asia, into some sort of a virtuous relationship and a virtuous circle with Europe and with the democracies of the world. Those of us who were brought up in Ukrainian diaspora families knew that was never going to happen. But you know, many people in the West had deluded themselves. Germans were absolutely convinced that the Cold War was won by their policy of Ostpolitik, not by the fact that Ronald Reagan bankrupted the Soviet Union with Star Wars. And they were absolutely convinced that you could do business with the Russians. And we saw this all the way up until 2021. And you know, it's a lesson. It's a lesson for businessmen. It's a lesson for lawyers, and it's a lesson for a lot of people that there is a cost to doing business with autocrats, dictators, and tyrants. And so, I mean, what we've had is essentially a war of aggression that is not a territorial land grab. It's not just a territorial land grab. It's really a decision taken by Vladimir Putin that the time was right to destroy the rules-based international order. He much prefers a rules-debased international disorder because it means that he can manipulate the fears, he can manipulate the societies of his enemy, which is the democratic West. And he played everybody. Russia has been weaponizing international law. It has been weaponizing the fears of the West. It has been weaponizing the economic interests of many countries in Europe that enabled this aggression by doing nothing after he invaded Georgia, after he invaded the Donbass, after he annexed Crimea, after the atrocities in Syria. His conclusion was that while we were concluding, or you were concluding, that we can still bring him on side, just one more concession, one more form of compromise, one more appeasement. And for dictators, and this is a big lesson for all of us, is that for dictators, appeasement just means you double down. It means your enemy is weak, and that weakness is to be exploited. And what it's meant is that Ukrainians are paying for that policy, those policies that the West has pursued over the past 15, 20 years today. Nobody expected to happen what is happening today, except that Ukrainians and their allies, and especially in neighbors in Eastern Europe, who have felt the warm embrace of the Russian bear in the past, understood very clearly that this was not going to end well. And what we've had essentially is it's not just, as I said, a land grab, and it's not just a geopolitical play. It's all about the extermination of a nation. It's about the extermination of a people, a culture, a language. Somehow, if you're not Russian, then you are a Nazi and you deserve to die, and you will die. And so Ukrainians have exhibited tremendous bravery. People have been commenting on this throughout, that how is it possible that Ukrainians have fought this hard? And it's frankly because we have no choice. And we've held off the enemy. Not only have we held off, we've started to take our land back. And even though people have felt that Bakhmut was a stalemate and nothing happened for 6 months, and this was a bad thing, this was a deliberate policy on the part of the Ukrainian military and the political leaders to degrade and attrit the Russian army, and to make sure that when we were ready to launch our counteroffensive to take back the rest of our territory, that they would be weakened sufficiently that they would not be able to provide the kind of defense that their numbers would otherwise warrant. And so we are where we are today. We have slowly retreated out of Bakhmut proper, in the center of the city. That city of formerly 70,000 people does not exist today. It's essentially been leveled. New York Times put out a video the other day that was just horrible in terms of what the devastation there. And now we're flanking around them. So we may actually end up encircling the Russian army in Bakhmut. And I think this presages what we're doing now is we're doing what the military calls shaping operations. And that means that we are degrading them, we are positioning ourselves, we are bombing their fuel depots, ammunition depots in deep behind their lines. And to really win, we're finally getting what we've always been asking for, and that is long-range missiles. And we finally got a decision this week that we would get F-16 airplanes. Part of the problem has been, to date, we could have done this offensive back in November, December, and I know that was one of the plans. And but we didn't get the decisions on supplying us with the tanks and the heavy armor and that we needed. So what when we do our counteroffensive, and it will be, people say, well, how can you do it? Because they're too well dug in. There's too many Russians in Zaporizhia along the south. They've got all these dragon's teeth anti-tank defenses. Well, you really think we're going to go there? We've had 3 successful counteroffensives that have been successful precisely because we fight asymmetrically. And I think you will see some very significant surprises, including in the air. We've been developing a drone army. And this is actually the story of this war. It's not the government that has been developing the drone army. It's the people. Friends of mine are doing it in their garages. Others are reconfiguring their businesses, their manufacturing facilities. And this is a case of total resistance. And that has been our success to date. And that is why we will win, because everybody is involved. People like myself, who never picked up a rifle until January or February, are supporting the military in a military capacity. Others are involved in medical assistance. Others are with food drives and all sorts of other volunteer efforts. And if you're not on the front, you're working for the front. And this is really important. So I always get asked, what does victory look like at the end of the day? And I think President Zelensky has been very, very clear about what that means. That means total collapse and total defeat of the Russian army in Ukraine, return to Ukraine's sovereign borders of 1991, full, including Crimea, and reparations and a war crimes tribunal. And I'll take these in order. My own view is, despite everybody's fears, and that's been one of the greatest weaponizations in this war, is that President Putin has weaponized the West's fear of escalation. Every time I hear that word, I just break out in hives now. And because instead of being risk informed, the West in many respects has been risk adverse. And it took a while, and it took the strength of our, let's call it, the testicular fortitude of the Ukrainian army to hold the Russians off and to reclaim its land, and to show the West that you get your mojo back, and we can do great things together. It took a while to get there, and it meant that we were not getting the weapons, we were not getting them in the quantities, and we were not getting them in the times that we needed them. And so it cost a lot of men and women their lives. We actually have 40,000 women in the Ukrainian army, 5,000 of which are in frontline combat roles. I believe that's more than in the Army of the United States of America. And so it's that part of total resistance. When we talk about victory, I believe that we're going to see a collapse of the Russian army. There is low morale, they're poorly led, they're poorly equipped, they're poorly fed, they don't want to be there, and our guys are highly motivated. On February 3rd, the government announced that there was going to be, they were going to create 8 assault brigades. That's 3,000 to 5,000 people in each one. By February 12th, 9 days later, 25,000 people had signed up. And we now have so many that we have a 9th brigade that's been put into place. So morale on our side is high. People are tired. People are fed up. But he could not bomb us into oblivion. He could not turn out the lights. Whatever he threw at us, all it made us do is double down. So victory means that I believe the Russian army collapses. It's completely destroyed in Ukraine. And then we can talk about negotiation. There cannot be negotiation. There will not be negotiation until the Russian army is weakened to the point where we can reclaim all of our territory. Too much brutality, too many women and children raped, too many children taken from their parents and put up for adoption in Russia, too many mass graves across Bucha, Irpin, Izium, Mariupol. 89% of Ukrainians have said that they would not want to have 1 square centimeter, 1 square inch of Ukrainian territory left in Russian hands, even if Putin used tactical nuclear weapons against us. And I see it in the people that I train with in my unit. that there's nobody saying that we should give in. So what happens after victory? And I think that this is very important. I think we're already talking about the reconstruction. We're talking about opportunities, especially in the energy sector. The energy disputes are already, lawyers are sharpening their knives. They're already taking place in Ergo Atom, the nuclear power regulator, Ukrenergo, the electricity regulator. These are the generator. These are all places where you are going to see very significant room for BIT arbitrations and other forms of dispute prosecution. But more than anything else, there is an enormous hunger in Ukraine for justice. And that's where you get that 89% of people saying, even if you throw nukes at us, we're not going to give in. And that really translates into the fact that we desperately are going, and we're going to continue to fight for a war crimes tribunal. The fact that an arrest warrant has been issued by the ICC has been excellent because it opens up a claim for genocide against Putin and his henchmen, and reparations. We all have to wrap our heads around how to get past sovereign immunity defenses and things like that. But I think that this really points to the fact that if Ukraine is now at the epicenter of global change, that global change also affects the international legal profession. And it may mean that it's time to move the dial on the understanding what public international law stands for. It's not just a set of norms that are going to be slavishly adhered to. It's also about justice. And it may well be that we may have to carve out some exceptions to sovereign immunity for genocidal acts of aggression. And these are debates that need to be had in fora such as this and around the world, because we can never, if we are ever going to have some form of international restoration of the international rule-based order, we have to be able to not just defeat the Russian army, but show that that defeat is not in vain and that there is accountability for those actions, because China is watching very carefully. And if there is any territory of Ukraine left in Russian hands, this will be perceived as a defeat of the United States. Make no mistake about it. And that is going to have profound implications to not just territorial claims against Taiwan and other countries in Southeast Asia, but it also affects international global supply chains, currency flows, trade relationships. We're going to be looking at a very, very desperately less secure world. And I think that, part of what we're going to be looking at as well is Ukraine joining the EU and NATO. And that's going to be a game changer in the EU. I always used to talk when I was in the government about creating a European Ukraine. And now I think we actually, given the circumstances, may be looking at a Ukrainian Europe. Thank you very much.
Thank you, Dan. I mean, I have a couple of questions in terms of during the last 6 months, there have been some suggestions of trying to bring Ukraine and Russia to the table for some sort of negotiation, and I mean, some of those initiatives have been suggested somehow timidly by European countries. China has at some stage also talked about it. How realistic is that, and how open would Ukraine be to some sort of a deal that might compromise the territorial integrity of Ukraine? And I mean, that's a big question of, and that of course maybe come together with suggestions of the lack of infinite resources for the war, etc.
Well, let's start with the last point. the United States is our largest benefactor, is our largest benefactor and the largest supplier of weapons. It costs a total of 4% of the Pentagon's budget. It's 50 cents a day for every American. So when we're talking about resources, we're not talking about exhaustion of something that's going to deplete the ability of the United States or its allies to defend themselves. And in fact, we are NATO's eastern border right now. We have 2,000 Leopard tanks. 2,000 Leopard tanks. We're asking for 500 in Europe. I mean, what are those Leopards were specifically designed to shoot Russian T-72 tanks, which are shooting at us. So, I mean, the war that all of Europe and NATO has been planning for is right now taking place on NATO's eastern flank. So it's happening here and now. For any negotiation to succeed, both parties have got to want to find a solution. As Golda Meir famously said that when they want to kill us and we want to live, there isn't a lot of room for compromise. And Putin's happy to sit down at this stage, happy to sit down at the negotiating table, so long as it involves the total capitulation of Ukraine. And Ukraine is prepared to sit down at the negotiating table, so long as it involves Russian troops leaving the territory of Ukraine in its entirety. So we're not there yet. We don't have any of the conditions that would result in a meeting of the minds. And when people say, well, why don't you leave him Crimea? I mean, that is just the most insane suggestion that you can think of. For one, who's going to police that agreement? Is America going to put boots on the ground? Is the EU going to put boots on the ground? Can you trust the Russians to abide by any agreement? That's clearly never going to happen. Secondly, if you leave the Russians in Crimea, it's like putting an aircraft carrier pointed at the heart of Ukraine and in the heart of Europe that is basically going to yank everybody's chain anytime it wants to. You are going to continue to self-deter and to appease because of the consequences of not doing that. You no longer have free choice. You no longer are a full-fledged democracy because you're not freely choosing the course of action. You're going to take decisions based on the fact that you fear what is on your border. And leaving him in Crimea threatens Romania, Bulgaria, and even Turkey. Let alone it'll destroy our economy. There's no way anybody is going to send ships into our ports to take out, which is our primary way of getting our product to the rest of the world. So I think that there will be a negotiation at some point. I suspect that it would probably involve the capitulation of the Russian forces or some sort of exit that will lead to them leaving. I do not see a scenario. I really don't. And maybe it's aspirational on my point. Maybe my PTSD is so advanced that I can't see clearly. But I just do not see that. And Zelensky, as I said, President Zelensky has very little room to maneuver politically in this country to cede anything. We haven't even started our counteroffensive. I mean, let's see how that goes. Already in the West, you get a Russian originated narrative that somehow the counteroffensive can't succeed. All of our counteroffensives have succeeded. None of their offensive has succeeded. And, when I talk about the collapse of the Russian army, there's actually historical precedent. The Crimean War, the Russo-Japanese War of 1905, and in 1917, World War I, when 4 million men under arms, basically shot their officers, threw down their weapons, and went home.
Thank you, Dan. Before giving way to our esteemed panel in 1 minute, I have one last question, which is the hard line in terms of international criminal responsibility also a must in terms of respecting the rule of law, not only to achieve the Russian army leaving the Ukraine, but also making sure that there be some accountability under international law?
I think that's a really, really important question and a good point underneath it. Because look, you know, the destruction of international law has been just so egregious. They just don't care. They don't care what anybody thinks. There's been absolutely, in the way they treat prisoners, the way they treat civilians, the way they bomb civilian infrastructure, the wholesale destruction of cities, what they do to children. I mean, you know, you have kids at the age of 10 and 11 dying from rape inflicted injuries. I mean, how, and this is not just isolated incidences. So, I mean, you know, if you don't bring them to account for something like this, then we can just basically write off the international law as a way to guide us or even forestall some sort of behavior of states. And it'll be open season for other autocrats and tyrants and dictators to do similar things. I mean, we will be in a rabid Hobbesian world. It's almost too horrific to contemplate. Unless look, Russia, personally speaking, we make a big mistake when we treat Russia as a nation state. Russia is not a nation state. It's made up of something like 180 various ethnicities that have been colonized over the last 300 years. Russia is a genocidal, now terrorist, expansionist empire. And that's what Peter the Not So Great decided he was going to create when he actually created Russia. It was called Muscovy before then. No Russia existed until then. And Catherine took it to a whole new level. And so what we're seeing now with the collapse of the Soviet Union, with the collapse of the Russian army in Ukraine, with the problems that they're having, is the gradual decolonization of Russia. I was trained as an insolvency lawyer in Toronto. And one thing I learned early in my career was that you can drag out a collapse for a long time, and then all of a sudden at the very end, it's like a roller coaster. It just goes off the deep end. And I think that's what we're seeing now. But they have to be held to account. You cannot release Russia from its sanctions. In fact, they should be squeezed even more until such time as full reparations are made. And the fact that the people who have perpetrated these horrific atrocities are brought to justice. We as lawyers, I can't understand how we as lawyers could even contemplate that not happening.
Well, Dan, thank you very much. I know that that it has taken us some time to get you here because you're absolutely committed when in Ukraine to support the cause, and when not in Ukraine to manage relations so that the cause continues. It has been a pleasure, and thank you for your time, for being with us. And now we will give way to the panel, which is related.
Thank you for having me. Slava Ukraini.
Thank you.
Героям слава.
And much love to Ukraine. And now it is time to give way to the panel, which we have titled Ukraine and Ukrainian National and Assets, Options of International Arbitration and Litigation, Funding and Recovery. So part of the background to this panel is that while the war is being fought, while counteroffensives are being fought, us in the legal field, if we believe in the international rule of law, may also have a role to play when the rule of law is being breached. And this includes very areas of international law. The one area that involves the community that targets World Arbitration Update is international economic law, both arbitration, but also what comes next, including asset recovery, enforcement, etc. So we are here with an incredible list of panelists, all experts in their field, to have a conversation as to the options that may exist with respect to arbitration, enforcement, asset recovery, and funding, because as we know, proceedings do not happen in heaven. I mean, they do happen here, and they require resources. So with that, I would like to introduce to our wonderful and unique moderator, Luke. And Luke, you're gonna have to forgive me if I mispronounce your last name, Wojciechowski. He is one, perhaps the only one, but certainly one of the few Russia qualified barristers who represents multinational companies in cross-border disputes and provides commercially sensitive, practical counsel to clients operating in a high-risk jurisdiction. Luke is a US citizen who worked in Russia for over 10 years. He has extensive experience representing US and multinational corporations operating in Eastern Europe and other global markets to manage risk, compliance, and integrity issues, particularly those involving sanctions and corporate crime. Luke provides counsel on a variety of disputes, including litigation, arbitration, proceedings in international and government investigations. He has led business, legal, and organizational audits involving financial and anti-money laundering compliance, as well as in connection with allegations of corruption and commercial bribery. Luke, the floor is yours, and everyone is welcome to this panel. Take it away.
Thank you so much, Jose Antonio, and thank you to the World Arbitration Update and the sister organization, Washington Arbitration Week, for recognizing the importance of this topic. One thing that I am a special counsel at Pillsbury Winthrop Shaw Pittman, and I do specialize in the Eastern Europe and Central Asia regions. So as we move forward, we're all aware that Russia's war in Ukraine has caused significant damage to Ukraine's economy and infrastructure. Some estimates place the cost of rebuilding Ukraine into the hundreds of billions of dollars. And although Canada, the EU, UK, US, and allies have imposed economic sanctions on Russia, Russian individuals, private companies that include freezing a significant amount of Russian assets, repurposing those assets will not be as easy and will certainly require a deep and comprehensive undertaking within the legal community in order to properly navigate those multi-jurisdictional international legal mechanisms that govern freezing and seizure of assets, ownership, legal immunities for sovereign states, a number of other issues which we'll only be able to briefly touch on today, but which are extremely important as we move forward. As we navigate the complex landscape ahead, I think it's important to remember, and as we speak about this today within the panel, the recovery of Russian assets is certainly not merely a financial or legal endeavor as we go into our the legal part of it. And I think just to set this up, we need to think this is an opportunity to also demonstrate our unwavering commitment to the rule of law, stability, justice. It's an opportunity for us to restore faith in institutions, empower the Ukrainian people, and strengthen the foundations upon which a sort of prosperous European future can be built. So I'm confident that the work of our panelists and this and similar discussions will lay the groundwork for a brighter tomorrow, not just for Ukraine, but for the entire region. And I think it's an important context as we get into the nitty-gritty, perhaps, of the legal components. Our panel today combines various jurisdictional and professional backgrounds to speak about this issue. And today's format, just so we're aware, each panelist will be speaking for approximately 10 to 15 minutes, after which we'll open it up to a fireside chat discussion. And if you have any questions, put them in the chat, and I will put those together. And if we have time, we'll get to as many of those as possible. So without any further ado, I'd like to take the time to introduce all of our panelists, so we don't have to do that and break up the discussion as we go along. So first joining us today is Daniel. By the way, thank you, Daniel, for all of your insight. It's great to see you always. Daniel's partner in Kinsteller is Alexander Martinenko, partner in the Kiev office and head of the firm-wide dispute resolution services of Kinsteller. For those of you who are not aware, Kinsteller is an international law firm in Central and Eastern Europe, Turkey, and Central Asia, formed in 2008 from the Linklaters offices. in a couple of those jurisdictions. The firm currently employs over 250 lawyers and has a focus on business law and disputes in those emerging markets. Alexander represents clients in Ukrainian courts, including the Supreme Court, acts frequently as an expert on matters of Ukrainian law and international commercial and investment arbitration proceedings, foreign dispute resolution proceedings. Alexander is very well known in the Kiev market, a graduate of the Koretsky Institute of State and Law of the Ukrainian Academy of Sciences, the Kiev Institute of Industrial Property, and has an LLM from Harvard University. Following Alexander is Gene Bird. Gene is a partner with Fisher Broyles, which I think needs no introduction here. He has over 20 years of experience in international disputes, has handled cases involving the enforcement of foreign judgments and arbitral awards, discovery for use in foreign proceedings, asset recovery, and cases involving Foreign Sovereign Immunities Act. Gene has also represented clients in international arbitrations under the rules of leading international institutions such as the ICC, the LCIA. Gene serves as an arbitrator in international commercial disputes and is on the list of arbitrators of the Ukrainian Chamber of Commerce and Industry and the Vienna International Arbitration Center. Gene was born in Ukraine, in the United States as a refugee from the totalitarian Soviet regime. After graduating with an MS from Purdue, he obtained his JD from Rutgers Law School, where he later served as an adjunct professor teaching international litigation in U.S. courts. Gene is very frequent on the speaker market. We're very happy to have him as well, speaking at international conferences, and he's authored publications on international legal issues. Following Gene is John Buscariel from McCarthy Tétrault, the Toronto office. McCarthy Tétrault is a leading Canadian law firm that delivers integrated business law, litigation services, tax law, real property law, labor and employment law nationally and globally through offices in Vancouver, Calgary, Toronto, Montreal, Quebec City, London, and New York City. John is the head of the firm's international trade and investment law group and a partner in the litigation group, and assists clients in understanding how international trade agreements and foreign investment laws impact their business, and assist clients through the tangle of regulatory impediments faced by Canadian companies seeking to expand their business globally and to international businesses entering the Canadian market. John's expertise is also internationally recognized in the interpretation and enforcement of international trade and investment protection agreements. He's a graduate from the University of Toronto, where he received his LLB from the Faculty of Law and is a member of the Ontario Bar. In 1998, he received his LLM in International Trade and Competition Law from the Osgoode Hall Law School. John is also an adjunct professor at the University of Western Ontario Law School, where he designed and is currently teaching in anti-corruption law and its application international business course. After John, providing us with an insider's view from a funder is Mitra Chanelin, who is an investment manager and senior legal counsel based in Omni Bridgeway's Amsterdam office. Omni Bridgeway is a global leader in dispute finance, financing disputes from inception through trial, appeal, enforcement, and recovery, with over 185 specialists working in almost every region of the world. Dimitro, before this capacity, is a cross-border disputes lawyer and is responsible for originating, assessing, and managing funded cases with a focus on enforcement matters in EMEA. He brings to this role more than 16 years of experience in international dispute resolution and enforcement. Before Omni Bridgeway, Dimitro was counsel at Asters, the Ukrainian law firm, where he specialized in major banking fraud litigations, including the largest cross-border litigation case originating in Ukraine. Dimitro has a master's in international dispute settlement from Geneva University and a master of laws summa cum laude from the National University of Kiev Mohila Academy. He was admitted to the Ukrainian bar in 2017 and qualified as a solicitor of the senior courts of England and Wales in 2019. Finally, we're very happy to have a last-minute addition to the panel, Professor Chiara Giorgetti, who is professor of law at Richard Law School, immediate past chair of ITA's Academic Council, vice president of the American branch of the International Law Association, an elected member of the American Law Institute. She is also a senior fellow at Columbia Law School's International Claims and Reparations Project, where she advises Ukraine on international claims and reparations ensuing from Russia's aggression. She teaches and writes in the areas of international law, international arbitration, international dispute resolution, international courts and tribunals, and has authored or edited 9 books and over 40 articles and chapters, including International Claims Commission's Rating Wrongs After Conflict. Professor Giorgetti also is researching currently international claims commissions as well as ethics and drafting a code of ethics for arbitrators in issues of state responsibility. Before joining academia, she worked extensively with the United Nations in New York and Somalia and practiced international arbitration with White and Case in Washington, D.C. and Lalive in Geneva. Professor Giorgetti holds a law degree from Bologna University, an MSc from the London School of Economics, and an LLM and JSD from Yale Law School. She clerked at the International Court of Justice, and during her sabbatical leave in 2019-2020, she served as a scholar in residence at ICSID, working mostly on developing a code of conduct for adjudicators. So we have a great panel, so much expertise that we've pulled together today. And with that, I think we're going to move into Alexander, who's going to give us the Ukrainian perspective. Alexander, thank you very much for joining us.
Thank you, Luke. Thank you, everybody. Thank you, dear audience. We'll proceed with a bit involving of the warfare terminology because we are speaking about the war and the legal implications of the war that Russia wages against Ukraine. So before engaging with the enemy, one needs to do at least 3 basic things. One is to understand the enemy, to understand who he is fighting against. One needs to understand well the terrain on which one is to be fighting, and one needs to understand the ammunition that it has in its hands. Let's proceed, because we are fighting from the legal trenches. Let's proceed with these 3 elements. The first element, who's the enemy? The villain over here is certainly the Russian Federation. And the Russian Federation is quite a unique subject of international law, quite a unique player on the international arena for a number of reasons. First of all, it pretends that it is the unique successor of the former Soviet Union, which was to some extent in the perverted minds of the current rulers of Russia, was the somehow the legal successor of the former Russian Empire, and for that very reason, it has some historic rights in at least this part of the world, if not in the larger part of Europe. That's first. Second, as a matter of fact, Russia is the second most capable nuclear power nation in the world. Yeah. We don't know what is the real capacity and the real ability of Russians to use their nukes, because the use of conventional armaments proved to be quite a failure in Ukraine. They don't seem to be the second army of the world as they used to claim, but still the consideration that they have quite a good and spacious arsenal of nuclear weapons is quite a big, significant deterrent point for everybody in the world, just for the lawyers as well. Then, Russia is a UN member, and moreover, it's a member of its Security Council, and moreover, it is a permanent member. What are the reasons and why Russia became the member of the United Nations in the first instance, and then the member of the Security Council with the veto power? With the veto power is it's a subject. I'm sorry, I've been distracted by my kids. So it's a number to separate conversation. In my deep opinion, in my sincere opinion that I essentially nurture since 1991, Russia was simply bootlegged over there. Russia has no legal rights to occupy the space in the United Nations Security Council or the United Nations as well, basically as such. And for this particular reason, this creates yet additional challenge for all of us. Then what Russia does in order to do what it does at this particular moment essentially, one can might have noticed a long time ago, at least I have noticed it a long time ago, maybe at least 15 years ago, that Russia has already started at that time preparing to the current state of affairs, preparing to this war. And maybe not even to the war to Ukraine, because it was considering the war against Ukraine as sort of as a passing event, but a war in a larger sense against the Western civilization. What it means, step by step, gradually, seemingly unnoticeably, it started changing its domestic legislation in a way, in certain ways. First of all, it started. It put its domestic legislation in front of the international obligations of Russia. It prioritized what the national constitution and what the national laws says over what its international treaties say. It started subordinating judgments and awards of various foreign or international fora and courts and arbitrations and so on to the revision by its national courts. It started gradually revising, abandoning or annulling certain international treaties, which it felt were not quite comfortable for it to live with in order to attain its purported goals. And finally, it started misusing tremendously the other existing public international law mechanisms. What it means in reality, all of us who are in international arbitration, for example, they know that Russia is notorious for not complying with the decisions or awards of international investment or commercial arbitrations. Russia is not complying with the decisions of the European Court of Human Rights. Yeah, even it was not complying with them even at the time when it was still a member of the European Convention on Human Rights. At the same time, Russia tried to manipulate the public opinion in imposing the ostensibly legal solutions to the current factual situation. What I'm talking about? I'm talking about the very simple things. Russia occupied the Crimea. Russia occupied several parts of other Ukrainian oblasts and Ukrainian territories. And then Russia has taken a formal legal step to incorporate formally all of them into its own constitution. And right now, it says purely formally that those territories are our national territories. And for this reason, it has the nerve of calling emergency meetings of the of the Security Council of the United Nations, alleging that it is a victim of Ukrainian aggression because Ukrainian forces, they have they attack the Russian forces that are located in those territories, and they destroy the Russian ammunition that is located in that territory and so on. So from this point of view, you can see the villain who is improperly occupies a certain key place in the world most prestigious organization, and second, it makes all possible steps. It takes all possible steps in order to erode the current rule of law in public international law and national laws as well, and where it cannot or where it does not think it will be useful for it, it it is trying to manipulate it or to misuse the opportunities that are provided by the public international law rules. So against this background, we will need right now to assess the terrain where we play. And in terms of terrain, I mean both the public international law and national jurisdictions, national legislations of the variety of nations who are engaged in this conflict. Frankly, the terrain is not quite good. It's bleak. It is clear for all of us, for the specialists, that Russia has significantly violated the most fundamental norm of jus cogens, the fundamental principles of public international law, the prohibition of aggressive war. And everybody understands it. Yet everybody understands also the flip side of the coin, that the public international law proclaims this principle, but fails to impose the responsibility, the liability for its violation. And that became extremely vivid at this particular point in time. Second, Russia misuses other legal opportunities in order to retaliate against those quite, I would say, slim or even flimsy legal means that can be used at the moment in order to bring somehow Russia to justice. For example, you know this story with the International Court of Justice, International Court of Justice, sorry, International Criminal Court. International Criminal Court, Russia does not recognize its jurisdiction, yet International Criminal Court has certain jurisdictional capacity in order to investigate and rule on some absolutely most egregious and most groundbreaking crimes in it. And the International Criminal Court has announced that Mr. Putin will be put on the wanted list because on the basis of the human traffic charges. And what Russia did in return, Russia announced that it has initiated criminal cases against the composition of the court that was in charge of this particular criminal case, as well as the prosecutor was prosecuting it. So essentially, this is also quite a problematic means. From other public international mechanisms, what we can think of: International Court of Justice. Russia does not recognize its authority to review this case. We cannot go to International Court of Justice to sue Russia for violation of the public order of the global order. Any bilateral treaties either do not work or they are of very limited applicability over here. National legislation is also not quite in good shape, because if we're talking right now about bringing Russia to accountability for what it has done in terms of war-inflicted damage, basically we should understand that essentially nobody can do anything by using national means for one particular reason, because for sovereign immunity defense that Russia will immediately invoke in its own defense. So what it means for all of us, it means for all of us, and in my personal opinion, that we are standing at the times of decisive changes, and these changes, legal changes, both in public international law sphere as well as in national legislations, they are due. They are due, and we are to construct them with our own hands, because otherwise we will be just ending in nowhere, just with no solution. These changes have already started being constructed bricks by bricks, and my colleagues will highlight the most important developments in this. These are so far not groundbreaking changes, yet the very important steps that have been taken in order to lay down the foundations for the future for the future judicial or whatever legal proceedings against Russia. For example, we're talking right now about the financial damage. Financial damage, for some reason, we are concentrating Ukraine because Ukraine is obviously the victim of the Russian aggression, and a lot of Ukrainian nationals, both natural persons and legal entities, have significantly suffered from the consequences of this aggression. Yet we should not forget that there are a lot of other players, a lot of foreigners that have lost their property in Ukraine, a lot of foreigners have been murdered by Russian occupation forces on the territory of Ukraine. And finally, to put it absolutely bluntly, the overall cost of this warfare is being carried out by whom? By public authorities of the coalition member states. And where this money is coming from? It is not coming from nowhere. It is coming from the pockets of the taxpayers of all the coalition states. This is also war-inflicted damage. And from this point of view, I would like maybe for all of us to think about the situation in a more complex situation, not to single out only the Ukrainian nationals and the damage that was carried out was caused to Ukrainian nationals only. I urge all of us to think about it in a larger perspective and to think about the long-term solution that can be reached in order to prevent Russia from making any further aggressive moves against Ukraine or against anyone, any other country in the world. And second, bring just Russia to justice in terms of the economic cost of this move. Today, we still have some of the elements that can be used, some of the mechanisms that can be used to some limited extent, like, for example, investment arbitration cases against Russia. Yet the complex solution for the situation is badly needed. I'm absolutely convinced that we will eventually come to a dual type of solution. It will be a combination of legal mechanisms and political mechanisms. I'm pretty much sure that if Russia does not survive as a unified single state as it is now in its current borders, there will be success states who will be negotiating, who will be part of this overall solution in the future. Yet we are only at the initial steps of going forward. Yes, I finished. So thank you.
Thank you very much, Alexander. I think that's a good turning point to pass it over to Jean to talk about some of those mechanisms in a little more detail.
Good afternoon. Thank you to World Arbitration Update. Thank you, Luke, for the introduction. I'm humbled. I'm impressed with the Alexander's Sashko's presentation, and it was Danila, the keynote speaker, which really connects the human and the legal the legal ends, the legal dimensions of the situation that perspires that occurs right now in Ukraine. I absolutely agree that we do need new legal routes, new legal venues to be developed, and the views on Russia needs to be changed. Just as a side note, I've been doing various representing Russian clients and clients relating to Russia and Ukraine since mid-90s. And going back to beginning of 2000s, I noticed you saw the biggest problem that I noticed was the perversion of the notions of justice, perversion of the legal system in Russia. There were commercial cases back then, the bankruptcy cases, where conventional definitions of bankruptcy, of insolvency, of various actions and the asset freezing were completely turned around. And back then we looked at them and we thought we can fight them in the United States and other in the other Western countries where the justice is developed, and it's at least there is more there is a more deeper look into the facts and the circumstances of the case and the substance of the cases. But it seems to be this perversion of justice is now being used by Russian government, by Russia, by Putin, to justify what cannot be justified. The aggression in Ukraine, the tortures, the killing of thousands of people. And that's something that we'll need to expose. We all need to show how this can be fought, not only with our Ukrainian brothers who are fighting with their lives in the front, but also on the legal front, as we do here. And that I really appreciate this opportunity. And with that, I'll just give a brief overview of what options we have to fight in the United States and what are the challenges to these options. Give me a second. I'll try to share my presentation and see if that's going to work. Can you see my presentation on the screen?
Yes, looks good. Thank you.
Thank you. What are the options? I'd like to talk about the conventional options that probably been reviewed, and many of you are familiar with, but also some more rare and more unique options that are available specifically in the United States. Of course, number one is the recognition and enforcement of arbitration awards. As Alexander mentioned, of course, there are some situations, there are some cases where arbitration could be an option, where there is a claim that is based on the expropriation, where the claims that are primarily based on the claims that are based on the existing treaties for the protection of investments. There are existing treaties between Russia and Ukraine, and there were a number of cases that were brought by Ukrainian plaintiffs, Ukrainian claimants against the Russian Federation that arise out of the Crimea, out of the expropriation of their property in Crimea by Russia back in 2014. Most of these cases been concluded successfully with the arbitration award in favor of claimants, and some of these cases already ended up in the U.S. courts. Cases related to Crimea, and these cases do relate to the recognition and enforcement of arbitration awards. We'll talk more, I'll give you a few more details about that, but the next one is recognition and enforcement of foreign court judgments. Now, of course, if there is a foreign court judgment against a foreign country or against the foreign defendants, they can be recognized and enforced in the United States. There is the procedure is a little bit more complex than recognition of arbitration awards, but generally speaking, United States courts do recognize foreign judgments. The next, I'll talk about the ATS. This is Alien Tort Statute, which is a pretty ancient law going back to the 18th century that provides a cause of action for the certain types of violation of international law. The more modern law that was not long ago adopted is the Torture Victim Protection Act, and that again is a possibility under certain conditions to use it. Last but certainly not least is Section 1782 discovery, and we'll talk more about that. But that is essentially a collateral legal action where a party, an interested person, can seek obtaining the documents, documents and witness statements in the United States for use, in foreign or international tribunals. What are the challenges? Of course, one, the biggest challenge that already been referred to by Alexander, by Danilo, is the immunity. Immunity is a big one, and it applies to most of the options that I mentioned before. There are two types of immunities. There is a jurisdictional immunity, and there is also immunity from execution. That something that we'll just give a little bit more overview further down in my presentation. And then the last, but certainly not least, the impact of sanctions. The sanctions that are imposed by the United States that actually may limit the ability of claimants or plaintiffs to recover in any action where the defendant is subject to sanctions. So let's talk about the enforcement of arbitration awards. The New York Convention, of course, I assume everyone is familiar with that. Doesn't need to be addressed in details, but in essence, it provides for a expedited mechanism to enforce arbitration awards, and the United States certainly is not an exception. There is a law called Federal Arbitration Act. There's a Chapter 1 of the Federal Arbitration Act that relates to the domestic arbitration, and there is Chapter 2 of the Federal Arbitration Act that enacts the New York Convention and requires and obligates courts in the United States to enforce, to recognize and enforce foreign and international arbitration awards. There are hundreds, there are thousands of cases of recognition of arbitration awards where there are, of course, certain exceptions. There are certain defenses from enforcement, and these defenses are set out in Article 5 of the Convention. There could be defenses that are based on the notice requirements, based on due process requirements. There are defenses based on where the tribunal exceeded its authority, and there are others. But overall, the United States is a very friendly jurisdiction for the recognition of arbitration awards. The next is the ICSID. ICSID is International Center for Settlement of Investment Disputes, which is in Washington, D.C. And it's part of the Washington and set up pursuant to the Washington Convention. Many bilateral investment treaties, as well as multilateral treaties that allow arbitration of investment disputes, they provide jurisdiction. They provide jurisdiction to ICSID. The ICSID. The biggest difference between ICSID and the regular investment and the commercial investment arbitration that is not on the ICSID is that the enforcement of ICSID awards is much more simplified than enforcement of awards that are issued under the New York Convention. There is a expedited proceedings for that would even more simplified than the New York Convention proceedings. So that makes ICSID awards more appealable if you can get it. ICSID tend to be more expensive as far as arbitration concerned than investment arbitration under the New York Convention, whether it's Austral rules or other rules. But nevertheless, on the enforcement side, it's always it would be always worthwhile to look on the enforcement mechanism, because even though the ICSID proceedings are more expensive, there could be the money could be saved on the enforcement side. Lastly, but certainly not least, I mentioned about the foreign judgments. United States is pretty unique in that sense. There is no federal law that allows enforcement of foreign judgments. Foreign judgments in the United States are enforced based on a state law. Now that you should not confuse that with jurisdiction of federal courts. In most cases, you probably will likely have jurisdiction of federal court to enforce foreign judgment, but the federal court will apply applicable state law. And most states adopted a model law on the enforcement of money judgments. And if you have a judgment that awards assumes certain, that would be typically subject to that law. And the enforcement, again, and the courts are very friendly as far as the enforcement of foreign judgment concerned. I think one interesting point that I wanted to make in that regard, that the enforcement in the United States does not require reciprocity. So there are some cases where, for example, U.S. courts enforced Russian judgments, enforced Ukrainian judgments, and judgments of countries which do not typically afford reciprocity in enforcement of U.S. judgments. So we talked about so far about the legal acts or legal judgments that were obtained outside the United States and then brought to the United States at the point of where execution against certain assets would need to be made. Now, but the United States also provides certain substantive laws. It has substantive laws that allow claimants and plaintiffs to bring actions on the merits in the United States. One of these laws is the Alien Tort Statute. It was adopted in 18th century, one of the oldest federal laws still in effect, and it grants jurisdiction to federal district courts for all causes where an alien sues for tort only in violation of the law of nations or of treaty of the United States. So essentially, if the law of nation is an international law, and conceivably a person can sue under the Alien Tort Statute in the United States court, asserting the action ATS as a substantive law for recovery of damages. A lawsuit under the ATS can proceed for any harm resulting from a violation of international law, no matter where the harm occurred or who inflicted the harm, as long as the plaintiff serves process in the U.S. territory. Typically, the Alien Tort Statutes, most of the cases that were brought against the legal persons and natural persons. However, there were attempts to bring cases against the foreign states. One of the more recent, for example, cases was as a small case, but nevertheless attracted my attention. It's Namistyuk versus Russian Federation. It was here in Washington, D.C., in the District of Columbia, and where Ukrainian plaintiff asserted claims against Russian Federation for exactly what we are presently discussing, aggression against Ukraine. Unfortunately, the court dismissed that case based on the jurisdictional defenses. Again, there is a sovereign immunity. It's sort of an overall protective mechanism that allows foreign states, particularly Russia in this case, to escape being defended, being sued in the United States, unless there are certain exceptions apply. And we will talk about these exceptions. The next, just few words about tort subject to ATS. The ATS, the international legal norms that will qualify the cause of action under ATS must be specific, universal, and obligatory. Of course, examples are genocide, war crimes, crimes against humanity, paradigmatic violation of the law of nation under the ATS, even when committed by individual divorced from a state action. So mentioning what Alexander said about the arrest warrant that was issued against Putin, and another Russian official for trafficking, for illegal trafficking in children, that could potentially be one of the causes of action that were asserted under the Alien Torture Statute. The next one is the Torture Victim Protection Act. The TVPA suits can be filed against individuals who act in their official capacity. And plaintiffs, so it's very important. Plaintiffs can be either U.S. citizens or non-U.S. citizens. So there is really no limitation as far as the who can sue under the TVPA. But there is a limitation as who can be defendant. Defendant must be acting in an official capacity or at least appearing to be acting in such capacity. For example, if you take this infamous Wagner group, they could potentially be defendant. At least they position themselves as part of the Russian army, as part of the Russian, although they pretend to be a private quote unquote military company. Of course, there is a significant evidence that they're not. So I'll be wrapping up very quickly now. There is there is also discovery. There is other option that available in the United States, that discovery under 1782. Again, you can obtain evidence for use in foreign proceedings in the United States. The procedure for 1782 discovery is pretty simple, but it requires just presentation to the court that such discovery is required. So going back and again very quickly on foreign sovereign immunities, there is the major exceptions that a sovereign immunity that the law provides is a waiver, the commercial activity exception, expropriation, and arbitration exceptions. Arbitration exceptions, they applies to all arbitration awards. Potentially, there were some cases that were brought against Russia based on a commercial activity. And I gave this as an example. There is the Chabad case versus Russian Federation that was heard here in Washington, D.C. There is, in addition to jurisdictional immunity, there is also immunity against execution. That sort of goes separate, but at the same time parallel with the jurisdictional immunity, but can also protect Russian Federation. Lastly, but certainly not least, the impact of sanctions. The United States, by imposing sanctions, prohibits dealing with the assets of a sanctioned person. For example, if you, and in fact, there is a regulation, sanction regulations specifically provides that any enforcement of arbitral awards purporting to transfer or otherwise alter, affect property is prohibited unless license pursuant to this part. So if the defendant is a sanctioned person, a license is required. It might be possible to obtain a license. Excuse me. So I'd like to wrap up my presentation. And if there are any questions, we'll have time for discussion. Thank you.
Thank you very much. Very useful information. I think a great way to set it up, and just a reminder that this is being recorded, and so the presentation is available for anyone afterwards. Shifting gears slightly, but still staying within the continent here, we're going to move over to Canada, which has had some recent updates. John, a reminder again, is a partner in McCarthy Tétrault, based in Toronto, and we'll turn it over to you. This is an couple exciting developments.
Great, thank you very much, Luke. Can everyone see the screen there?
Yep, it is visible. Thank you.
Fantastic, thank you. And Luke, thank you to you for your moderating this, and to the World Arbitration Update 2023. to you and them for inviting me to appear. I do feel particularly privileged to be appearing among such esteemed speakers, listening to what's happened so far and anticipating what's going to come after me. I'm going to just spend about 10 minutes or so talking about a new mechanism here in Canada under our economic sanctions against Russia. And we are, as Luke noted, I practice in the area of international trade. The focus of my practice for a number of years now has been in the area of economic sanctions, export controls, and anti-corruption law and policy. On the Canadian side of things, as Luke suggested, there have been some major developments these past few months, particularly triggered by the Russian invasion of Ukraine. Just to put this in some context, in Canada, we have sanctions against 23 or 24 different countries. Of course, the ones that I've highlighted there are the ones that are the most active sanctions programs we have to date. Russia is there, but so is China, Belarus, parts of Ukraine that are currently occupied by Russia, are Russian forces, Haiti, Iran. They're all active sanctions programs that Canada has. So when I'm talking about some of these new mechanisms, just keep in mind, it's not only with respect to our Russia sanctions. These mechanisms apply across our sanctions programs. Very quickly, just generally on the Russian sanctions that have been imposed to date, they truly are, I think, really the most impactful sanctions regime in our modern history. Never before have we imposed sanctions to this extent on a target that was integrated into the world financial economy. And certainly, we've got very aggressive sanctions against North Korea, Iran, and Syria, but never have we hit a country like Russia before with sanctions to this extent, when we see Russian banks integrated into the international financial system. We see investments by Russian oligarchs all over the world. That truly is unprecedented, and we're seeing, within the last 12 months or so, just how impactful that has been. The sanctions can really be put into three buckets when you look at them. The first are, and these are the most important, this first bucket and what we'll be talking about today, and that's really the sanctions that are imposed against individuals and entities that are listed on our sanctions lists. Right now, Canada has listed over 24 entities and individuals. They include, this is solely with respect to Russia's invasion of Ukraine. They include Russian leaders, government departments, agencies, politicians, oligarchs, businesses, all the major Russian banks, the central bank, the Ministry of Finance, the Ministry of Justice. Just recently, the Prosecutor General was added to the list. That is a massive list. It is larger than any of our other sanctions lists, and I think that's probably the case for the other G7 and Western countries as well. Also, within the last couple of weeks, Canada introduced a new deemed ownership rule, and we'll get into that in a moment or two, but it's quite significant in the context of some of the measures we're talking about now. For many, many years, we have been asking for guidance from the Canadian government to determine how do we deal with entities that are owned or controlled by a party that's on the list. In the US, you have what's called a 50% rule, and there are similar rules in the UK and in the European Union. In Canada, we don't have a rule like that until now, and that's going to impact not only the obligations to freeze the assets of sanctioned persons, but also this new mechanism for forfeiture that the government has introduced, and we'll talk about in a moment. The other two buckets are really restrictions on providing goods and technology. There is a broad range of goods and technology you cannot provide to Russia from anywhere in the world, and you cannot source from Russia. So it goes in both directions. The final bucket refers to our services sanctions. Canada prohibits the provision of 30 categories of services to Russia or to persons in Russia. So let me jump to what I think is really at the heart of what's interesting for this panel today, and that's a new forfeiture mechanism that was introduced by the Canadian government back in June of last year. So under our autonomous sanctions measures, so these are our sanctions that we put in place, what we call made in Canada sanctions. We're not talking about the sanctions that are imposed by the UN Security Council and applied domestically by Canada and other countries. We're talking about autonomous sanctions measures. There's two in particular that are relevant for us here today. One is the Canadian Special Economic Measures Act, and we have Russia regulations that have been issued under that act. We have it for Belarus as well, which make up those sanctions, as well as the Justice for Victims of Corrupt Foreign Officials Act, what we call the Sergei Magnitsky Law for short. In those two pieces of legislation, the government has mechanisms already, and they've had these for many years, where they can force the seizure or restraint of assets or funds, property that are held by listed or sanctioned persons. That's been in place for many years now. What's different is, and what was introduced in June of 2022, was the ability now of our Minister of Foreign Affairs to not only order that the assets be frozen, but now go to a court and get a forfeiture order from the court. And there is a very low threshold in that legislation for obtaining that forfeiture order. The minister just has to demonstrate to the court that the property that it will be covered by the forfeiture order is described in the seizure order that the minister herself has issued. And secondly, that that property is owned by the person referred to in the seizure order, i.e. the sanctioned person. Once that's done, the court can issue a forfeiture order. Now, there's an ability for someone who may have some kind of security interest other than the sanctioned person, someone who has a security interest to get that interest recognized. And the court will hear from that person. The court can also hear from the sanctioned person. But at the end of the day, it is a fairly low threshold for the court then to issue a forfeiture order over that property of the sanctioned person. The second part of that provision is what's to be done once the forfeiture order is issued. So once a court issues that forfeiture order, the assets, or let's say the funds that are in an account in a bank here in Canada, those become the property of the Canadian government, and the Canadian government can dispose of them. It might be a hard asset that they can sell for, or they can just simply take the funds. But those proceeds must be paid out, but only for certain purposes. And those are listed purposes in the sanctions law. The first is the reconstruction of a foreign state that's been adversely affected by grave breach of international peace and security. The second is the restoration of international peace and security. And the third is for the compensation of victims of a grave breach of international peace and security, or violations of systemic human rights or acts of significant corruption. So again, the legislation isn't specifically mentioning Ukraine here, but Ukraine, the situation with the Russian invasion of Ukraine, the destruction of property in Ukraine, the required rebuilding that's going to occur that the speakers have already talked about, and we're shifting our attention to what's going to happen in that regard. All of that will fall under the scope of what the government of Canada can do with the assets that it's seizing and forfeiting. These are the assets that belong to sanctioned persons. The one thing I did want to mention, and I alluded to this earlier, we have a new deemed ownership rule here in Canada, and that really determines in what circumstances will the property of an entity that is connected to a sanctioned person be considered to be owned by that sanctioned person. Again, this has been an area of uncertainty in Canada for many years, for decades. And just within the last couple of weeks, the Canadian government issued some proposed amendments to our legislation, expanding essentially what can be considered the property of the sanctioned person, really looking at what are those connections that are necessary for the property of an entity to be considered the property of the sanctioned person that is associated with that entity. The first criteria, and any one of these is sufficient. The first criteria is if the sanctioned person holds directly or indirectly 50% or more of the ownership of the entity. So this is very much like the FAQ you have under your US, the OFAC FAQ under your US sanctions, called the 50% rule. Similar rules in the UK and the EU. The second, more significant one, I think, is if the sanctioned person is able to directly or indirectly change the composition or powers of the entity's board of directors. So in a situation, for example, where a sanctioned person like Roman Abramovich can appoint one of 12 directors to the entity, even if he has a minority shareholding or no shareholding at all. If he has the ability to change the composition of that board, the property of that entity becomes considered to be owned by Abramovich and therefore subject to this seizure and forfeiture action. So again, a very important rule in determining the scope of what can be seized and forfeited in Canada under this new rule. The third criteria is whether you've got a circumstance that it's reasonable to conclude, having regard to all the circumstances, that the sanctioned person is able to directly or indirectly, through any means whatsoever, direct the entity's activities. So very, very broad criteria, well beyond a 50% rule, broader than what exists in the US, the UK, or the EU for deeming ownership of an entity's assets when that entity has those certain connections to sanctioned persons. So this, I keep mentioning, this was introduced in June of last year. We do have a test case, one which the government announced in December. They issued an order to Citgo Bank to restrain about $26 million that they claim was held or controlled directly or indirectly by Roman Abramovich. And it's credited to a bank account that's held there indirectly through an entity which ties up to Roman Abramovich eventually. And they first issued the order, that's the seizure order, and then they publicly announced that they will be pursuing a forfeiture order in accordance with the mechanism under the Act to forfeit that amount of $26 million and then subsequently pay that towards reconstruction of Ukraine or the other objectives under the Act with respect to compensation of Ukraine for the Russian invasion. So that's one. There hasn't been any further public developments since that was announced, but we suspect that's going to be heating up shortly, so watch for that. The second one, it's a little less clear on this, but for those of you that have been to Toronto and ever driven by Pearson International Airport, you will notice that there is a massive transport aircraft that has been parked to the side of the airport, but fairly close to the highway. And it's an aircraft owned by Volga Dnepr. It's an AN-124, one of these massive transport aircraft. When sanctions came into place, Canada imposed a prohibition on Russian aircraft coming into or leaving Canadian airspace. They were stuck, that aircraft was stuck here and hasn't been able to leave Canada since just days after the Russian invasion occurred and sanctions were imposed back in February 2022. On April 16th, the Ukrainian Prime Minister came and visited Prime Minister Trudeau here in Canada, and he announced that Canada will be handing over that aircraft to Ukraine. And what isn't clear is whether that is going to be done under this new forfeiture mechanism, or as we understand it, there's been reports that this and other AN-124 aircraft have been subject to a court order, a forfeiture order from a court in Kiev, or in Kyiv, that has essentially ordered these aircraft forfeited and that they should be returned to Ukraine because of certain safety violations with respect to the aircraft. So whether Canada will use this new mechanism or whether Canada is going to use a mechanism just to recognize that Kyiv court judgment, or it's going to be a combination of both, isn't quite clear yet from the reports. But that's another one we're keeping a close eye on, just to see how this mechanism, this new seizure and forfeiture mechanism is going to work in practice. So finally, let me just end on issues and implications. I do think this forfeiture mechanism is truly unprecedented, and it's different from other forfeitures you're hearing about in other G7 countries that are going on. There is no underlying criminality that's required to be demonstrated here. So typically when you have some kind of asset forfeiture, there's underlying criminality. The funds or the property are used in the connection with a commission of a crime, and you see this very frequently on the US side. And there is a forfeiture of that property that the Department of Justice, for example, in the United States can pursue. In Canada here, under this mechanism, you do not have to demonstrate any criminality. It's simply if the person, the company or the entity has been added to the sanctions list, that is sufficient. No underlying criminality has to exist. The other thing to keep in mind is I think we'll see a number of challenges to this measure as the Canadian government starts to use it more frequently. In Canada, we have a division of powers between our federal and provincial government, and there are arguments that when it comes to property, which is the domain of the provinces, that the federal government may not have jurisdiction to actually expropriate and forfeit this property and distribute the proceeds because they are invading or getting into provincial jurisdiction. Another issue around our Charter of Rights and Freedoms, it has prohibitions against unreasonable search and seizure, and whether this could be considered an unreasonable seizure under our charter, although typically that doesn't benefit foreign companies, but certainly if a Canadian is involved in this, they would have the benefit of those protections. And we've been talking about using bilateral investment treaties today to deal with the damage that Russia is causing in Ukraine. We could potentially have Russians using a bilateral investment treaty to address the forfeiture of these assets. Canada and Russia do have a bilateral investment treaty in place. It was put in place, initially negotiated with the Soviet Union in the late 1980s. In 1991, the Russian Federation became an acceding party to that bilateral investment treaty. And it is an old style investment treaty. There are no exceptions for actions taken for purposes of essential security interests, something you see more often in the new treaties, certainly in Canada's new model bilateral investment treaty. That does not exist in the Canada-Russia treaty. So it will be interesting to see how, if and when these forfeitures take place, how the Russian investors might react in terms of using the investor state dispute mechanisms under these BITs to challenge these expropriations to get compensation. The other element here will be challenges by entities that might be owned or somehow connected to those sanctioned persons. So I said, under this new deemed ownership rule, there's very broad ability now of the government to get the assets of these entities that they might be only 10% owned by a sanctioned person. But again, if the sanctioned person can change the composition of the board of directors by electing one of 12 board members, that's enough to deem the property of that entity to be property of the sanctioned person. And now you can use the mechanism to seize and forfeit that property. Now, how exactly that'll work out when that entity will come forward and say, well, they're only a 10% shareholder. Surely, we can't forfeit 100% of this property. That's going to have to be worked out by the courts. But the position of those entities that are partially owned or have that connection to the sanctioned person will be an important part of how I think this unfolds. And then finally, of course, this is, when I say this is unprecedented from a sanctions point of view, it truly is unprecedented in the sense that in the past, when we impose sanctions on bad actors, the intention usually is to freeze the property and try to effect a change in behavior. Once you have taken the step of forfeiting the property and effectively distributing the proceeds of that forfeit action, there's no turning back. There's no incentive anymore for behavioral change in those circumstances once those steps are actually taken. And so this is something very new for us in the sanctions space. It is something that really hasn't been done, at least in our modern sanctions programs before. And it will raise the risk of retaliation. And so Canadians who have investments in Russia, who have facilities in Russia, and they may have mothballed them and they may have tried to really reduce their activities in those facilities. If they still have that property there, they could be subject to retaliatory measures by the Russian government, which is something we would be watching for as well. So Luke, I'm going to stop it there, and happy to answer any questions when we come to the question period.
Absolutely fascinating. It's so interesting to see how it's going to be progressing with this creeping expropriation you have in Russia and with your BIT. I mean, I cannot believe you. Just to confirm, you can change 1 out of 12 board members. That is still a change of the composition of the board.
That's right.
That is very interesting.
That's right.
Thank you very much for that. Yeah, that was great. Dimitro, we're going to hand it over to you without wasting any more time here. On my end, we'd love to hear how the funding world is looking at this and what the opportunities are, and how to work with you moving forward, and how you see the situation.
Thank you, Luke. Thanks everyone for coming, and I will try now to to put up my presentation. Just a moment. Yeah, I hope you can see it. Yeah. Okay, so while I was listening to the presentations before me, it became quite clear to me that we are not alone in this estimate of the current position on the international legal market, which is basically, in a few words, that it's really very hard to have Russia responsible for the damage caused by the war using the existing legal mechanisms. And while it's really hard to get a merits judgment or award, it's even more hard to enforce it. It also means in the end that it's very hard to fund a case against Russia. And the reason for that is what was very correctly noted by Alexander, that for years Russia has been strategically withdrawing from various international legal instruments and kind of safeguarding itself against international mechanisms to have it liable for the breach of international law, for the breach of human rights, and so on. So we have various options that would normally work against a normal state, including investment arbitration, including even local court proceedings. All of this, we have a really hard time working against Russia. And there was some hope maybe associated with the sanctions regime, that the rest of the assets might become available for enforcement. But as far as as matters stand now, this is mostly the matter for the future, whether these assets will be available. Until now, as far as we're aware, at least, of course, this is not completely public information. There has been no clear and successful effort to turn sanctioned assets into damage compensation for a specific private person. That's why my presentation will not really deal with the instruments that we have now. It will be more like forward-looking in terms of what we expect, we as funders expect to happen, and what we are relying upon for the future. Because obviously there is a huge problem of the compensation of damage caused by Russia, and there must be a solution found, and we expect it to be found. But what the solution might be. So just by way of a little introduction, we just that's basically us. The big blue dots are our offices. We also have an office in Paris, which for some reason is not here. The dark color are the countries where we estimated, funded, managed claims. The blue ones are where the jurisdictions where the claims we have assessed but not funded, and a few white ones are the countries that we haven't invited yet. Yeah, that's a few African countries, maybe. Yeah, Afghanistan didn't happen to come across us now, but closer to the business, we have some experience, quite actually significant experience, with the Iraq debt reconciliation program. I'm not trying to make a complete analogy here, because for one, at least very obvious reason, that in that reconciliation program, Iraq took part, while we do not really see any intention by Russia to take part in any kind of program like this. But the effort we are seeing that's going on in the international community, we think will be, might be at least, guided by the previous experience of the debt reconciliation programs. Even in the situation where the damaging country, the respondent country, will not be taking part in this. So for us, the Iraq debt reconciliation program, for us as funders, it was a big success. Basically, the substance of it was not so much a litigation effort, but a reconciliation by a third party, which means that the commercial claims, there was a mass of commercial claims, about 20 billion in total claims, and they were very highly dispersed. So about 70% of them were below 10 million, which I think on a bigger scale will be will be the case here as well. So we will have probably millions of claimants that have suffered from the actions of Russia, and lots of them might have really small claims. So that's why the dedicatory approach to this task might not really work very well, because or it might, but again, this is something to be decided. But I just wanted to highlight that there was an experience, and that experience for us was quite beneficial. So this is in light of what has been said before, that the current existing mechanisms do not really work very well. A mechanism like this, the mechanism like the Iraq debt reconciliation program, is something that we might be looking forward to as an option for us to assist our clients and to obtain the compensation. So it's a mechanism that is yet to be established. So in that mechanism, in the Iraq program, we had the mandate for about 300 million and actually recovered about 120 million. So that was, it can be discussed whether that was really a success, because of course the haircut was quite significant. But again, in the end, the issue of the wartime damage caused by the Iraq war was to an extent settled by this situation. So now I'm moving more to Ukraine and to Russia, and this is about the register of damage that has been introduced just a few weeks ago, probably. My colleague, Professor Giorgetti, will speak about it in more detail, but I will just make a very, very small introduction, because this register of damage is something that we are very much interested in, because it really provides us a way forward to take part in the damage compensation mechanism. So basically what we see now, what has been adopted by the Committee of Ministers on the 12th of May, is that there will be an organization under Dutch law, I think, that will deal with basically taking all the claims for damage into a single database. So it's not yet a claims commission or a claims compensation commission. It's just a register for the claims against Russia for the wartime damage. And this is the stage when we, in principle, we haven't considered this yet in much detail, but we are basically thinking that this is one of the opportunities where we can already start working on taking part in this scheme. I will probably pass on for more details to Professor Giorgetti, because she was indeed the person behind this, and she's much more competent than me in discussing this. I can only note that today the Minister of Justice of Ukraine, the Deputy Minister of Justice, as far as I remember, made a statement that this register will be operational in August this year. So this is something that's basically going on right now, and something that is to be developed in the coming months very shortly. In terms of how we approach the compensation issue, because the register has been only created basically last month in May 2023. Before that, we have established and run for a number of clients so-called Ukraine Compensation Initiative. It's like a small program inside our firm, which permits the people who have suffered, well, individuals, also business entities who have suffered from war damage caused by Russia, to have their claims registered, apprised, due diligenced, and reviewed by our specialists. And in case we, as the funders, see an opportunity to enforce them and to obtain compensation, then we can provide funding for those claims. But basically, this is a kind of a small register that we run on our own for our own clients. So we invited a lot of claimants to register for the Ukraine Compensation Initiative, and we have had quite a number of registrations. So in a sense, we are at least to an extent prepared to meet the potential compensation initiative that is going on, and that's has been promoted through this register and through the Committee of Ministers. I have here a few details how the compensation works in terms of the Ukraine Compensation Initiative, but basically I can say that with the establishment of this register, the compensation fund and the claims commissions that are the matter for the future, all of this will be revised. But we are working very closely, and we are looking very closely at the developments in this sphere, and basically we are preparing ourselves for this inflow of potential claims, even at the stage where the commission has not been yet set, but the register is already there. So now I'm gonna steal a little bit. That's us from Omni. I'm gonna steal a little bit Luke's job and just say that the next speaker will be Professor Giorgetti, who will be more competent and knowledgeable about the register that has been established recently. But and this is the point where I have to wrap up. So, but I will be happy to respond to any questions if any during the follow-up.
I mean, and I apologize, we have not been very good at keeping on track with time, and I know Professor Giorgetti, you have to leave soon, so thank you for your time. We'll pass it over to you for whatever time you can give us.
Well, thank you very much. Thank you for the invitation, and thank you to the Washington arbitration update for inviting me to and to look and to everybody else. Yes, I think what it shows, I think our time is up in about 1 minute. But what it shows is really there's so much interest on Ukraine and issues of compensation for Ukraine that maybe we should organize another panel specifically on the register of damages. But anyways, for the minute maybe that I have, look, do I have a minute? I don't know. I don't know if it's a hard stop. The 2 o'clock, but let me.
I don't think we have a hard stop unless Jose Antonio tells it differently. So I think as long as you know, I know you have to get leaving, but feel free to give us as much time as you'd like, and anyone who wants to.
Oh, okay. Well, with the indulgence of the audience, I'd like to do very briefly. So I want you to make 3 points, really. One is what are claims commissions, why claims commissions for Ukraine, and how would it work in practice? And I'd like to build on what previous speakers have already said. What are international claims commissions? I think it's very interesting. This is dispute resolution mechanism that often occur after war, after conflict, and that created under public international law. So you were talking about an international legal instruments rather than a domestic one. And they provide compensation for injuries to a variety of claimants and claims. And this make them very, very flexible instruments and very ad hoc instruments that are responsive to specific needs. What is interesting that separately to differently from other mechanisms that we discussed about is that the jurisdiction of claims commissions can be very much targeted to whatever the needs are, and they can include both injuries suffered, compensation for injuries suffered by individuals, but also injuries suffered by companies or states, the state of Ukraine or others, or other possibly other states. And there are some very interesting examples that exist. So historically, this goes back to the J Treaty of 1794, but there are, of course, some more recent examples that are very instructive, and I heard some of them maybe be mentioned already. One is the Iran-US Claims Tribunal, the other is the United Nations Compensation Commission, and the third, more recent, is the Eritrea-Ethiopia Claims Commission. And what is interesting is these 3 different kinds of commissions have had, to different degrees, very successful compensation mechanisms, have established very successful compensation mechanisms that have been able, for example, in the case of the UNCC, to provide compensation for 1.5 million successful claimants and for over 52 billion claims. So claims commissions can create very expedite processes, and then can expedite processes, especially for individuals, and include mass claims processes, including sampling and other technical issues. How are these claims commissions created? And this is possible, the difference that we have here for the situation in Ukraine. The Iran-US Claims Tribunal and the Eritrea-Ethiopia Claims Commission both were created by a bilateral treaty. Although, if I had more time, I could talk a little more about the treaty that created the Iran-US Claims Tribunal, which wasn't really bilateral. But anyways, it was an international instrument. The Eritrea Claims Commission was certainly created by a bilateral treaty. The UN Compensation Commission was created instead by a Security Council resolution. These possibilities don't really exist for the situation that we have now, because Russia, of course, has a veto at the Security Council, and it would be very difficult to have a bilateral instrument being created now. So enter here an example of what we have just approved with the Council of Europe. So a very different, unique instrument that is targeted still, is very flexible, and is targeted to compensating claims for individuals and claims from states, again, in a mass claims mechanism with a lot of flexibility. But in a very different kind of setting. And here, what the experts and negotiators have suggested and have used is looking at the United Nations as a supporting actor. And here I would just like to say very briefly that I have the honor to sit as an expert in an expert group that was nominated by President Zelensky in May 2022 that includes other professors and other experts. And we've been working on these issues. And so one important mechanism that we suggested and has been then adopted is using the General Assembly to provide the General Assembly of the United Nations to provide kind of this external support using the a special provision of the General Assembly rules, which allow the General Assembly through the Security Council kind of mandate to also work on issues of security. And so a special session was called first in March 2022 in the immediate aftermath of the invasion, and several very interesting resolutions were approved by the General Assembly. And I'd like to just very briefly talk about those because these are the foundation of what we have then for the Council of Europe. The first, the Security Council resolutions 11.1 of March 22 is very important because it provides a very direct condemnation of the aggressions of Russia of Ukraine's territory. And this is very important because it's the very foundation. Here there is a very specific recognition that Russia has violated international law, and that this in a separate and subsequent resolution of 14 November 2022, again, a ES resolution 11.5 of 2023, the General Assembly specifically said that there is a obligation of Russia to pay compensation. So there is a violation of international law, and there is an obligation of Russia to pay compensation. How can we do that? Then taking back to the mechanism that we have created, that we've talked about the Claims Commission, the General Assembly called for the creation of a registry of damages as a first step, taking the example of another registry of damages that was created in the aftermath of an advisory opinion by the International Court of Justice on the issue of the building of the wall in Palestinian occupied territory by Israel. And taking that example, recently then, the Council of Europe on May 12, 2023, created such registry. So a registry that recorded damages, and so this is the first step to the creation of the Claims Commission. So the first step is a creation of a registry of damages that would record all the damages that were suffered, the injuries that were suffered by individuals and by companies and by states caused by the aggression of Ukraine by Russia. And so the first part would be a registry, and the registry will have the Council of Europe resolution of May 12 also include a statute of the register. And the register provides for, first of all, an executive director and executive secretariat to be established, and then the board of commissioners. And the executive secretariat will carry the day-by-day mandate, the work day-by-day of the register. And the board of commissioners will then oversee and decide what are the claims and damages that are admissible. This would be mostly of an administrative issues, waiting for the creation then of the Claims Commission. At the beginning, so I was interested to hear, of course, Dimitri is also talking about the statement today that the Register of Damages will be functional very soon. The Council of Europe has created with the resolution an enlarged partial agreement that doesn't only include the members of the Council of Europe, but also includes others, including Canada, Japan, and the United States. Those countries will then come together as and nominate both the executive director and the commissioners, who will have then the role to specifically and detailed the heads of claims, of course, with kind of taking into consideration and applying what we already have from the General Assembly, the Council of Europe resolution, and the statute, create specific rules on what are the claims, how to file claims, and how claims can be reviewed and then categorized by the registrar. And again, I think what is very important is that this resolution provides specifically for the creation then after the registry, or maybe in conjunction and parallel with the registry of the claims commission, they will be able then to compensate financially those who have suffered injuries. So I think this will conclude my presentation. I'd like to thank you very much for giving me a little time, and I hope I didn't take advantage too much of the post 2 o'clock hour, but I'd like to thank you for the possibility of talking.
Not at all. In fact, I think we would, if it was up to us, we'd continue listening to you for as long as you were willing to give us the time. So thank you very much for that. I think in the interest of time, and we do have a lot of participants who have left, we'll probably have to move on from here. But just to say to all the panelists, thank you very much. I think it was a great discussion. I'm quite sure that this is the first in many of these to come forward, and I hope we were able to set some sort of base for everybody that participated, and all the questions that you have. I think we can. There's an email link to Jose Antonio's email. If you want to shoot them out, we'll see what we can get to be able to respond. I see there are some in the chat already. So thank you, everybody. Have a good afternoon, and I look to see you at future events when we consider these important issues.
Thank you. Bye-bye.
Thank you, everybody. Thank you. Bye-bye.
Thank you very much.